Greetings, our fellow Americans. We are anonymous. The Fourth Amendment states the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So in other words, you have the right to feel safe that no one is permitted to just go through or take anything from your pockets, your home, your documents, your bags, your wallet, or even your anal cavity, without having a warrant. And the warrant must be specific. To a key, the Fourth Amendment was to guard against unreasonable searches and seizures, along with requiring any warrant to be judicially sanctioned and supported by probable cause. Search and seizure, including arrest, should be limited in scope according to specific information supplied to the issuing court, usually by the law enforcement officer, who has sworn by it. However, this is another constitutional right that has gotten into a fight with a black marker. Over the course of a few hundred years, there have been subtle changes and allowances to our constitutional rights. Our forefathers predicted this and would roll over in their graves if they could read some of today's warrants and probable causes. There are many examples, but one is the open fields that states pastures, open water, and woods, etc. may be searched without a warrant, on the grounds that conduct therein would have no reasonable expectation to privacy. The doctrine was first articulated by the Supreme Court in Heister versus the United States in 1924, which basically stated that the Fourth Amendment does not apply to private property open fields on the grounds that open fields are not a person, house, paper, or an effect. The question that you should ask is, what is your body, house, documents, and everything you own? Is it not personal property? Property being the key word. This doctrine was drawn up in the 1920s. A similar case on the open fields doctrine was Oliver versus the United States in 1984. The police ignored a no trespassing sign and offense, trespassed onto the suspect's land without a warrant, followed a path for hundreds of feet and discovered a hidden field of marijuana. The Supreme Court ruled that no search had taken place because no privacy was expected regarding an open field. Why growing a plant in the land of the free would be illegal and we would spend so much money to prohibit it is beyond us. Especially since we are so far into debt we cut humane public services. Our forefathers did write in the Declaration of Independence that whenever any form of government becomes destructive of these ends, it is the right of the people to alter and to institute new government, laying its foundation on such principles. This would bring one to believe that they intended on those who would rule the free to take over eventually, and for the free to stand up and take back control.